Have you ever felt like your landlord suddenly changed their behavior or took a negative action right after you exercised one of your tenant rights, perhaps by asking for a much-needed repair? It can be a very uncomfortable and stressful situation, making you wonder what your next steps should be. Well, tenant rights against retaliation are legal protections that prevent landlords from punishing tenants for legally exercising their rights. Essentially, if a tenant engages in a protected activity, the landlord cannot take adverse action against them as a form of punishment or revenge. This is a crucial safeguard for renters everywhere. The core mechanism behind these rights is to ensure that tenants feel safe and empowered to advocate for their living conditions without fear of reprisal. Without these protections, tenants might hesitate to report unsafe conditions or enforce terms of their lease agreement. Protected activities often include reporting code violations to authorities, requesting necessary repairs, joining or organizing a tenant union, or asserting any other right granted by their lease or local law. Landlord actions that could be deemed retaliatory range from issuing an eviction notice without proper cause, increasing rent unfairly, decreasing essential services like heat or water, or harassing the tenant. The specific laws and what constitutes retaliation can vary significantly based on your state and local jurisdiction, making it vital to understand the rules where you live. If you believe you are experiencing landlord retaliation, there are practical steps you can take. First and foremost, document everything thoroughly. Keep detailed records of all communication with your landlord, including dates, times, and summaries of conversations. Always try to communicate important matters in writing, such as emails or certified letters, so you have a clear paper trail. Gather any evidence related to the protected activity you engaged in and the landlord's subsequent actions. Research your local and state tenant laws to understand your specific rights and the definitions of retaliation in your area. If the situation persists or escalates, consider reaching out to a tenants' rights organization or consulting with a housing attorney for guidance. A powerful tool in many tenant protection laws is something called the presumption of retaliation. This means that if a landlord takes certain adverse actions, like trying to evict you or raise your rent, within a specific time frame after you've engaged in a protected activity, the law may presume it is retaliation. The burden then shifts to the landlord to prove their actions were for a legitimate, non-retaliatory reason. This presumption period typically ranges from 3 to 6 months in many jurisdictions, offering tenants a significant advantage in proving their case. Knowing about this specific legal concept can make a big difference in how you approach such a situation. Understanding your tenant rights against retaliation provides a vital layer of security and peace of mind in your rental journey. It empowers you to assert your legitimate concerns and maintain a safe, habitable living environment without fearing unfair consequences. By knowing these protections and how to act on them, you are better equipped to navigate challenges and ensure a fair and respectful tenancy, ultimately leading to a more stable and positive home life.